All right, well, good morning, everyone. Thank you for joining us today and welcome to the Rocky Mountain ADA Center's virtual workshop presentation of Know Your ADA Rights. My name is Emily Schuman. I'm the director here at the Rocky Mountain ADA Center, and I will be your facilitator for today's webinar. I am a white woman in my late 30s with shoulder-length brown hair, wearing a gray t-shirt and black cardigan against a green background. I'm also joined today by Jessica Lucinia, who is our instructional designer. She'll be moderating today's webinar, assisting with the Q&A at the end of today's presentation, and working with you all in the chat should you have any issues accessing the presentation today. Real-time captioning is provided for this webinar. The caption screen can be accessed by choosing the caption icon in the meeting control toolbar at the bottom of your Zoom window. During this session, only speakers will have audio. If you do not have sound capabilities on your computer or prefer to listen by phone, dial 1-719-359-4580 or 1-669-444-9171, and then use the webinar ID 984-0767-8034. And please note that this is not a toll-free number. So this webinar will qualify for Certified Rehabilitation Counselor or CRC continuing education units, as well as Society of Human Resource Management or SHRM recertification credit, and will also qualify for elective credit toward an ADA coordinator certificate training program, which is administrated by the Great Plains ADA Center. Please note that if you need a training certificate for these credits, or simply just because you want one, you must send us an email with your full name to email@rockymountainada.org. We will only be sending certificates upon request. And Jessica will put that email address in the chat as well. If you experience any technical difficulties during today's webinar, please send a private chat message to the host by typing in the chat window. Type your comment in the text box and hit enter. For keyboard-only users, you can hit Alt-H to access the text box. You may also email, again, email@rockymountainada.org, or you can call us at 719-444-0268, and that is voice and relay. Okay, so again, today's webinar is titled Know Your ADA Rights. We're hosting this webinar in celebration of the ADA's 35th anniversary, which is actually tomorrow. So we're offering the webinar to help the public learn about the history of disability rights, and then learn more about present day ADA rights. So in today's session, we're going to cover the ADA's history and purpose, who the ADA protects and what it covers, how to access your ADA rights, such as asking for an accommodation, and what to do if you have been discriminated against or you feel that your rights have been violated. And then finally, we'll discuss where you can get more help and resources after today's session. We'll also have a live Q&A session at the end of the webinar, so you can ask your own questions. I would recommend sending in your questions as soon as you think of them. Please note that we will not be going in great depth today, so we're going to encourage you to continue to follow up with the ADA National Network if you have questions beyond what we cover in today's session. I really want to make sure to note that the ADA is designed to apply case by case. So this means that there's many different factors on how the ADA might apply in your individual situation. And so again, we really recommend that you get in contact with an information specialist at your local ADA center to more fully understand your rights and your options for support. These can vary by location, as you know, each region and each state has different resources and mechanisms for enforcement. So again, your regional ADA center can be a great resource to you moving forward. So our slides and a captioned version, or a captioned recording of today's webinar will be made available on the event page for this webinar on our website within the next few business days. And then a quick access note, most of the slides presented today will have images on them. Meaningful images will be described, but decorative images will be not. However, there is alt text provided on all images, which you can access directly in the slide deck once that's been posted. Okay, so speaking of questions, we are going to be covering quite a lot of information today. So we encourage you to submit your questions as soon as you have them, and we will address those questions at the conclusion of today's session. Also, please note that Jessica may respond to your questions in writing or chat with you in the chat box to help you through if you're having an issue. Again, you may submit your questions using the Q&A text box on the meeting control toolbar. So please do use that Q&A button rather than putting your questions in the chat area. You can also use that Q&A button to and when you submit your question, you can choose to submit your question anonymously if you so desire. If you're listening by phone and you're not also logged into the webinar and can't use the Q&A function, you can also email your questions to email@rockymountainada.org. Okay, so with that, let's jump right into it. So this, once again, is the session Know Your Americans with Disabilities Act Rights. Once again, this webinar is being put on by the Rocky Mountain ADA Center. My name is Emily Schuman, and I'm joined today by Jessica Lucinia. I do always have to start with a little bit of a disclaimer, which is just to let you know that the information, materials, and guidance that you are getting today via this training session should not be considered formal legal advice, nor will they be binding on any enforcing agency for the ADA. So again, this information is meant to be informal guidance, and you will need to work with an enforcing agency or a legal representative if you have such a need. I also want to let you know that the Rocky Mountain ADA Center is operated by the University of Northern Colorado and is funded under a grant from the National Institute on Disability, Independent Living, and Rehabilitation Research, otherwise known as NIDLR. And we our region consists of Colorado, Utah, Montana, North Dakota, South Dakota, and Wyoming. And our goal is to provide information, technical assistance, and training on the Americans with Disabilities Act. So if you're not familiar with the ADA National Network, I want to make sure that we spend a moment just reminding you or orienting you to this network. So the Rocky Mountain ADA Center is part of a larger ADA national network of 10 regional centers. And all of the centers are available to provide that information, training, technical assistance, materials, and research, really just all things ADA related. And so you have, no matter where you are in the country, you will have an ADA center that is assigned to you and is available to take your questions, to provide you with information, and to just, to be connected with. So for any questions you have moving forward. The most important thing that I want to leave you all with today about the ADA National Network is, again, that idea that as you have questions that come up about exercising your rights or knowing what your rights are, or maybe if your rights have been violated, The regional ADA centers have information specialists on hand who can provide free and confidential technical assistance. So you can call us, email us, get in contact with your regional center, and you'll be able to speak to somebody who is an expert on the ADA, and who can help guide you as far as, have my rights been violated? And if so, what do I do next? Should I file a complaint? These information specialists can also help you work through the process of, maybe you're just not quite sure how to request a reasonable accommodation or how to ask for some sort of disability related assistance. And these information specialists are on hand to help with that. So we do have lots of things that, products and services that we offer as regional centers. But again, I just want to make sure that everybody understands that you have free and confidential technical assistance available to you at any time, no matter where you are in the country. So you can call that 800 number, 1-800-949-4232, and that will automatically connect you to your local ADA center based on your phone number. Or you can visit adata.org, and you can determine which ADA center you are assigned to based on where you live from there. So before we can understand our rights today, I think it's important to understand some of the critical moments in history that led up to the passage of the ADA. The history of disability rights is vast, and so we're only going to be talking about a few of the most notable moments. But I hope this, what the information that you receive today will spark an interest to learn more about disability history, and potentially continue learning about that on your own. I really do believe that it's critical to understanding where we've been in order to understand where we are now. So, as you may already know, the ADA is a civil rights law, and segregation and discrimination are violations of basic civil rights. Regardless of a person's or organization's intention, the fact is that when a building does not allow a person who uses a mobility device to enter into the building, that is discrimination. When information is only available to a person who is sighted, it's discrimination. Or when information, is only accessible to someone who can hear, that is a form of discrimination. When an employer focuses on how a job has to be done, and not the purpose of the job, that could be a form of discrimination. When a business will only provide access to their establishment if somebody doesn't use a medical device, that is a form of discrimination. And when a state and local government fails to recognize and provide services for all of its citizens, regardless of their ability, that is a form of discrimination. So the ADA aims to eliminate these types of segregation and discrimination and open doors for everyone to live independently and equally. So on this slide, it's a black and white photo of a pivotal disability rights march during the 1990 Wheels of Justice campaign in New York City, which was part of the national advocacy effort leading to the passage of the Americans with Disabilities Act. So the demonstrators in this photo, many of whom are using wheelchairs, are moving down a city street holding a large banner, which reads, "Injustice anywhere is a threat to justice everywhere," which is a famous quote by Martin Luther King Jr. Some of the notable activists pictured include Judy Heumann, who's in sort of the center left, wearing sunglasses and a white shirt. You see Justin Dart to the right of the image, wearing a cowboy hat and a suit. And then between them, near the center of the image, is Brad Lomax, who's a key figure in both the civil rights and disability rights movements. And he's wearing sunglasses and a tank top with a camera around his neck. So this photo really captures the power and unity of disabled activists demanding equal rights and justice. And we'll talk more about some of the folks in this picture as we go on. But let's go back in time, way farther back to the very founding of our country, and recount some of the most critical moments in disability history. So in 1776, we know that the United States signs the Declaration of Independence. And not many people know that one of our founding fathers, Stephen Hopkins of Rhode Island, had cerebral palsy. And you can see in this image, his signature appears on the Declaration of Independence, and the lettering is shaky because of his disability. And during the signing of the Declaration of Independence, he's famously quoted as saying, "My hands may tremble, but my heart does not." In 1817, the American School for the Deaf opened as the first US school for deaf students. It was started by a wealthy surgeon whose name was Mason Fitch Cogswell, and his daughter Alice became deaf because of a fever. Cogswell and 9 other supporters wanted to serve the 84 deaf children living in New England, but at this time, almost no one in America knew how to teach sign language. So they sent Thomas Gallaudet to Europe, where deaf education was way far ahead than in America. And in Paris, he studied at Paris's famous School for the Deaf, and eventually convinced one of its teachers, Laurent Clerc, to return with him. And so together they started the American School for the Deaf, and it began with just 7 students. One of the first students was also Alice Cogswell, and eventually Congress gave the school land in the Alabama Territory, making it the first United States school to receive federal aid. Thomas Gallaudet served as the American School for the Deaf's principal until 1830. And then his son later founded Gallaudet University, which, like the American School for the Deaf, taught mainly in American Sign Language, which was built and developed from Clerc's Parisian signs and other methodical signs. So Gallaudet University, you may be familiar with, is still a leading university for the deaf and hard of hearing today. But for each advancement for people with disabilities, another step back was taken. So you're going to see this pattern continue throughout the history that we're talking about. 2 steps forward, 1 step back, right? So in 1841, we see P.T. Barnum of Barnum and Bailey Circus fame, right? Starts a museum and begins to exhibit, quote, freaks as a form of entertainment. So these exhibits were people with disabilities, right, exploited for the entertainment of others. Some of the conditions that were deemed, quote, freakish and worthy of display included muscular dystrophy, bone, skin, and hormone disorders, dwarfism, congenital disorders, missing or extra limbs, albinism, and so on. And so this is a shameful time in disability history. And you see this in these images at the top. We have P.T. Barnum pictured with Charles Stratton, who's also known as General Tom Thumb, and that's a person with dwarfism. And in the bottom image, this is Chang and Eng Bunker, and they are conjoined twins from what is now called Thailand, but used to be called Siam. So then we get to 1861 to 1865. So around this time, we have 3.1 million soldiers who fight in the Civil War, resulting in some 60,000 amputations, limb amputations, based on war injuries. Because of that, what's called the Invalid Corps was established by the federal government to help to employ disabled veterans in war-related work. But the disabled veterans who sought this protection under the law were often portrayed as immoral, shirkers, malingerers, freeloaders. So, basically, there were still a lot of attitudinal barriers going on here. Interestingly, in North Carolina, they provided over 1,500 veterans either an artificial leg or the equivalent sum of money at the time, which was $70. That would be roughly around between $1,300 and $1,500 today. So this is interesting to note that, similarly to the attitudes after the American Civil War, passage of the ADA sparked widespread criticism, of a similar nature. People assumed that the law is for people to receive unnecessary handouts or gain special privileges. So in 1883, we see Sir Francis Galton, who is Darwin's cousin, writing what's called Essays in Eugenics. And eugenics is the science of improving a human population by controlled breeding to increase the occurrence of desirable heritable characteristics. So this was developed largely by Francis Galton as a method of improving the human race. And it only fell into disfavor after the perversion of its doctrines by the Nazis. But prior to that, Americans actually really embraced the eugenics movement, and it was used to justify laws that prevented people with disabilities from moving to the United States, marrying other people with disabilities, and having children. Eugenics laws also led to the forced sterilization of disabled adults and children. And many people are surprised to learn that the 1935 Nuremberg racial hygiene laws were modeled after the United States eugenic laws. So some of the horrendous things we know about what the Nazis did was actually modeled off of some of the things that were happening in America before that. And so this image shows a black and white historical illustration titled Steps in Mental Development. And this depicts a pseudoscientific hierarchy of intellectual capacity based on this early 20th century eugenics ideology, right? So the graphic shows these cartoon figures ascending a staircase labeled with offensive and outdated terms like idiot, low-grade imbecile, medium-grade imbecile, high-grade imbecile, and moron. And so, each of these categories is associated with some sort of work capacity. So things like, if you're an idiot, you're only capable of self-preservation. If you're a moron, you may be able to do work requiring reason and judgment. If you're a medium imbecile, you may be able to do simple manual work. So again, very offensive and shameful time in disability history. So then we have ugly laws. So this went on from the early 1880s until all the way until the 1970s. The United States had what are called unsightly beggar ordinances, which were punishable by fines and jail times. And these became known as ugly laws. And these types of ugly laws were often used to control the use of public spaces by people with disabilities. And this continued to occur, and these laws continued to be used even after the signing of the Rehabilitation Act of 1973. So I'd just like to share the text of one of these laws from the city of Denver, Colorado. Again, our center is based in Colorado. And so this language is from the Denver law in 1886, and it says, quote, any person who is diseased, maimed, mutilated, or in any way deformed so as to be an unsightly or disgusting object, or an improper person to be allowed in or on the streets, highways, thoroughfares, or public places in this city, shall not therein or thereon expose himself to public view under the penalty of a fine of $1 for each offense. Okay, so thankfully in the early 1900s, we once again see some positive disability related legislation related to disabled veterans. So in 1916, we have the National Defense Act, which gave pension benefits to service members who were wounded or disabled during their service. In 1917, we get the Smith-Hughes Act, which created a federal board of vocational education. which provided guidelines for instruction and study of occupations, which included vocational and medical rehabilitation to injured war veterans. And in 1918, we see Smith-Sears Veterans Rehabilitation Act, which expanded the role of that Federal Board of Vocational Education to retrain veterans from World War I. And this act was also known as the Soldiers Rehabilitation Act. So many people in the audience may be familiar of the case of Buck versus Bell. This is one of the key moments in disability history. So in Buck versus Bell in 1927, this was a United States Supreme Court ruling that upheld a statute that instituted forced sterilization of people with cognitive disabilities. And justified this by saying that it was for the quote protection and health of the state. This is largely seen as endorsement of negative eugenics, which is again the attempt to improve the human race by eliminating undesirables from the gene pool. And so the story behind the case is this. It starts with Dr. Albert Sidney Priddy, who was the superintendent of an institution called the Virginia State Colony for Epileptics and Feeble-Minded. And he filed a petition to his board of directors to sterilize Carrie Buck, who was an 18-year-old patient at the time in the institution who Priddy claimed had a mental age of 9 years old. And you can see in this image on screen, on the left is Carrie Buck, and on the right, to her right, to the right of her is her mother. And so Dr. Priddy maintained that Carrie represented a genetic threat to society because according to him, Carrie's mother had a mental age of 8 and also had a record of prostitution and immortality. Apparently, Carrie's mother had 3 children without good knowledge of their parentage. And so Priddy's justification was that, there's already been several generations of people who have these intellectual disabilities. Right. So Carrie, one of the 3 children, had actually been adopted early on, and was able to attend school for 5 years, and she was able to successfully reach the grade 6. So she achieved 6th grade. But according to Priddy, she had actually eventually proved to be incorrigible, quote, incorrigible, and eventually gave birth to an illegitimate child. And so because of that, her adopted family had her committed to the state colony for, citing that she was feeble-minded and no longer capable the family was no longer capable of taking care of her. And it was actually discovered that Carrie's pregnancy was actually not caused by an act of immortality on her own part. In fact, in the summer of 1923, while her adoptive mother was away, her mother's nephew assaulted Carrie, and that resulted in her pregnancy. And so we know now that her commitment is probably an attempt to save an attempt by the family to save their reputation or protect their reputation. So the facts of this case, as you can see, aren't true at all. However, this case eventually made it through the courts, and on May 2nd of 1927, in an 8-1 decision, the Supreme Court of this country accepted that Carrie, her mother, and her daughter were all feeble-minded and promiscuous, and decided that it was in the state's best interest to have Carrie sterilized. And so this ruling legitimized Virginia's sterilization procedures until they were finally repealed in 1974. And more importantly, this Supreme Court decision effectively removed all restraints for people who were eugenicists, right? And by the 1970s, over 60,000 people with disabilities were sterilized without their consent. And even though forced sterilization on the basis of disability has ended on paper, the Supreme Court's decision has actually never been overturned. Okay, so now we're in the 1930s. And this is when we get the Social Security Act. So we get Social Security appearing for the first time in 1935. And Social Security was passed by President Roosevelt, who we know was the first US president with a significant physical disability as the result of polio. In the pictures you can see here, in the top picture, you can see President Roosevelt in his wheelchair. And then you can see him as he in the bottom image as he is normally pictured, where he's sitting behind a desk in order to conceal his wheelchair use. So the first version of the Social Security Act provided old age benefits and funds that went to states for blind and disabled children. It also extended some vocational rehab programs that were targeted for people who were unable to work. It really represented a significant increase in grant awards and financial support from the federal government for the benefit of people with disabilities. In 1938, President Roosevelt also founded the organization that we now know as the March of Dimes. And so this is the organization that initially focused on combating polio, but over the years, the March of Dimes has evolved into working to address emerging maternal and infant health issues through research, education, advocacy, and community programs. So in the 1940s, we see quite a bit happening with legislation and advocacy. So in 1940, we see the National Federation of the Blind being formed. This is they advocated for white cane laws and input by blind people for programs for blind clients, right? So Nothing About Us Without Us, the National Federation of the Blind, is still very active today. In 1944, we see the National Mental Health Foundation that was founded by World War II objectors who chose to work as attendants in state mental institutions instead of serving in the military. And they, because they worked in these institutions, they had the opportunity to witness and expose some of the abusive conditions that were happening in these mental institutions and facilities. And so they became the driving force behind the movement towards deinstitutionalization of mental health patients. In 1945, President Harry S. Truman signed Public Law 176, which created what was called at the time National Employ the Handicapped Week. We now know this as National Disability Employment Awareness Month, or NDEAM. This is something that many of you will be familiar with, and we celebrate this every October, National Disability Employment Awareness Month. And this is a month-long observance promoting the employment and inclusion of people with disabilities in the workplace. And then in 1946, we have President Truman signing the National Mental Health Act, which called for the establishment of a National Institute of Mental Health. Okay, in the 1950s, again, quite a bit is happening here. So between 1949 and 1953, unfortunately, we see researchers from MIT and Harvard, along with the Quaker Oats Company, conducting a study at Fernald State School in Massachusetts. Again, this was another institute for people with disabilities. And in this study, they actually fed radioactive isotopes to institutionalized children without giving them informed consent to study how minerals are absorbed in the human body. And so obviously this is a very unethical experiment that exposed vulnerable children to radiation and later became a significant example of unethical medical research practices. In 1958, Ginny Laurie began publishing the Toomeyville Junior Gazette, which is a grassroots newsletter for polio survivors that eventually evolved into the Rehabilitation Gazette. And this was an early but very influential voice for advocating for disability rights, independent living, and cross disability organizing. So it really had the impact of connecting people with different disabilities, and played a pivotal role in fostering that sense of community and advancing the disability rights movement. And then all throughout the 1950s, we see Social Security being expanded. So in 1950, it's expanded to provide direct financial aid to disabled people. And then in 1954, we see the disability freeze amendment happening, which protects future benefits. So if a person becomes disabled later in life, they can still have access to Social Security benefits for the time during which they were not disabled. And then disability insurance for workers aged 50 to 64 was launched in 1956. So we know that it's SSDI. And soon those payments were extended to spouses and their children. So really this paved the way for what we know as the modern Social Security system that we have in place today. Okay, so then we enter what I call the disability rights era. So this is, a couple of decades here, really between the 60s and, the turn of the century, where several things, many different disability rights laws were being implemented, and disability rights was really starting to get some traction. And this really kicked off after the passage of the 1964 Civil Rights Act, and really was inspired by and came on the heels of that civil rights era. So if you're not familiar, the Civil Rights Act of 1964 is a classic civil rights law that prohibits discrimination on the basis of race, religion, national origin, and sex. But it did not include protection for people with disabilities. But it did provide a framework and a foundation that was eventually used, to kind of formulate what we know the ADA to be. So in 1968, we see the Architectural Barriers Act, which mandates that federal buildings have to be accessible to people with disabilities. And then in 1973, we see the Rehabilitation Act, which again gives protections for people with disabilities, but is limited to those federal programs and programs receiving federal funding. In 1975, we get the Individuals with Disabilities in Education Act, or IDEA. And so this is, if you're familiar with like a IEP at school for children with disabilities, that came about from that law. In 1976, the Higher Education Act Amendment was passed to include students with disabilities, protections for students with disabilities. In 1986, we get the Air Carrier Access Act, which provides protections for air travel for people with disabilities. In 1988, we get the Fair Housing Amendments Act. So again, this act was amended to include protections for people with disabilities, and specifically mark people with disabilities as a protected class. And then finally in 1990, we get the Americans with Disabilities Act. And then in 2008, we get the ADA Amendments Act. So I'm going to talk a little bit, obviously more in depth about those. But first, I want to highlight some of the critical activism that we saw play out during this disability rights era that really helped to advance disability rights and, really make it happen. So first of all, I want to share with you about the 504 sit-in. So again, I'm sure many of you are familiar with this. In 1977, the disability rights movement had reached a pivotal moment with the 504 sit-in at the San Francisco Federal Building. And this is where activists actually occupied the building for 25 days to demand the implementation of Section 504 of the Rehabilitation Act of 1973, which prohibited discrimination against people with disabilities in federally funded programs. So Judy Heumann, who you can see in this image toward the right, wearing a looks like sort of a striped knitted dress. Judy Heumann is a prominent activist, perhaps one of the most famous disability rights activists there has been. And she is a wheelchair, or was a wheelchair user due to polio. And she was one of the key organizers of this protest. And she was able to leverage her experience and her leadership skills to really galvanize support and bring attention to the cause. And then alongside her, to the left of her in this image, is Brad Lomax, who is a Black activist with multiple sclerosis. Again, we mentioned Brad at the beginning as well. And Brad Lomax was also a member of the Black Panther Party. And this is a really, he played a really crucial role in making the 504 sit-in happen, because he was able to secure support from the Panthers. And they, with their support, the activists who were doing the sit-in were provided daily meals, and other critical supports that they wouldn't have been able to go as long as they did without the support of the Black Panther Party. So the combined efforts of all of these activists not only led to the successful enactment of 504 regulations, but they also really highlighted the fact that disability is intersectional, right? So, disability crosses and overlaps with all kinds of other social justice movements. And so again, this is really always seen as a critical advancement towards equity for people with disabilities. And this type of protest and activism became really powerful in the disability rights world. So, because we're located in Colorado, I love to point out that Colorado was central to the disability rights movement, particularly in the 70s and 80s. Denver was one of the first cities to have accessible mass transit. And this is thanks in large part to the work of the Atlantis community, ADAPT, and the Gang of 19. So in 1975, Reverend Wade Blank, who was a passionate disability rights advocate, started the Atlantis community in Denver. And he really found his passion for disability rights after he had been working in a nursing home. And he, had been working to help people who were living in that nursing home be able to move out of the nursing home and live their lives independently. So the Atlantis community is started in 1975. And then just a couple of years later, on July 5th and 6th of 1978, Reverend Blank and the Atlantis community held protests in Denver against, to protest the wheelchair inaccessibility of public buses. And so this was the country's first demonstration for wheelchair accessible public buses. At these protests, 19 Atlantis community members, who we now call the Gang of 19, blocked buses with their wheelchairs and chanted, "We will ride." So, again, this was a really powerful statement to people that we are not able to use this public service. This was not designed for us. It's not accessible to us. So we're going to we're going to prevent this bus from going anywhere until we can have access to it and have an equal opportunity to use the bus. And then if fast forward to 1983, there had been several years of similar local bus protests across the country that had inspired a national movement. And from there, the Gang of 19 started a group called ADAPT. And the group at that time was formed, of course, to advocate for wheelchair accessible lifts on buses. And so their original acronym was ADAPT originally stood for Americans Disabled for Accessible Public Transit. And their campaign for accessible bus lifts expanded out from Denver to cities nationwide. I know there's some famous images of adapters in Atlanta, who, again, they really became renowned for their strategy of blocking buses to draw attention to the need for wheelchair accessibility. So wheelchair users would stop a bus in the front and in the back, and then others would get out of their wheelchairs and actually crawl up the steps of an inaccessible bus to make an even greater statement. So after years of this type of protest and lawsuit, bus lifts finally became required when the Americans with Disabilities Act was signed into law in 1990. And adapters, at that point, they expanded their advocacy for to include disability matters outside of transportation, while continuing to ensure that follow through of the transportation provisions in the ADA. So the group's name today, ADAPT, now stands for Americans Disabled Attendant Programs Today. And these organizations, Atlanta's Community and ADAPT, are both currently still active. Okay, so then fast forward to March of 1990. At this point, the ADA had been introduced into Congress, but it was pretty certain, the disability community could tell that lawmakers would stall on passing the bill if people with disabilities didn't make a strong statement as to the need for civil rights, a comprehensive civil rights law of their own. And so they knew from all of the activism work of the past that a really strong statement would be to use their own bodies and mobility devices to make a statement. So on March 12th of 1990, in what is now known as the Capitol Crawl, to symbolize the barriers confronting disabled people, more than 60 activists abandoned their crutches, wheelchairs, power chairs, and other mobility devices and began crawling, and in some cases, really dragging themselves up the 83 stone steps that lead to the United States Capitol building. And so in this image here, this is one of the most famous images of the Capitol Crawl. We see 8-year-old Jennifer Keelan, who, is wearing a red and white bandana and sort of has her face pointed toward the camera. So she has cerebral palsy. She was 8 years old in this picture, and she famously declared, "I'll take all night if I have to." And this moment is widely remembered because it's just so powerful to have a child with a disability understand that this is such a critical moment for the rights of people with disabilities, that if it has to take all night to crawl up those stairs, it's worth it. It's an important statement to make. So this powerful demonstration drew national attention, which led to increasing public support and really significantly influenced the ADA's passage later that year in July. So, I would say that this worked. This protest took place in March, and then in July, just a few months later, we have the passage of the Americans with Disabilities Act. So on July 26, 1990, President George H.W. Bush signed the Americans with Disabilities Act, or of course we call it the ADA, into law. And the ADA is a civil rights law that affirms the inherent dignity of people with disabilities in America. And as a civil rights law, it prohibits discrimination against people with disabilities in areas of public life, including jobs, schools, transportation, and public and private places that are open to the general public. And the purpose of the law is really to make sure that people with disabilities have the same rights and opportunities as everyone else to live, work, and play. And one of the most famous quotes that President George H.W. Bush said as he was signing the ADA into law is, quote, "Let the shameful wall of exclusion finally come tumbling down." And so you can see now we've gone through some of this history, and we understand what that shameful wall of exclusion and discrimination actually looked like. Um, so really the ADA is meant to be a promise to correct all of those mistakes of the past and all of the ways that people with disabilities were left out, left behind, mistreated, and discriminated against. So let's get in from here. We're going to get into the ADA's, what the ADA says and what our rights are, what rights the ADA gives us. So it's important to note that the ADA is descriptive, not prescriptive. So this means that the ADA does not prescribe exactly what to do in every single situation. So it simply could not have been as comprehensive as it is if it had to predict all of the possible variations of disability, changes in language and technology, and all of the various areas that it applies to. So instead, the law is descriptive. So it just describes what non-discrimination should look like. So it gives you the end goal of non-discrimination. And then it allows for some flexibility and nuance in terms of how the ADA applies and is interpreted. Its broad nature, is seen as a positive because it allows it to be implemented across many different sectors, and it's by design meant to be applied case by case. So we always say there's no one size fits all solution for the ADA. Really, because no two people with disabilities are exactly the same. Two people can have the same diagnosis or disability and have different, experiences with that. So the ADA should apply differently for each individual with a disability. So for that reason, you might often hear us say it depends as it relates to the application of the law. So there's often many factors that we have to look at in order to determine how the ADA applies in that situation and what the best ADA accommodation or solution might be. So after the law was passed, lawyers really tried to narrow down who is disabled and who isn't. So to remedy or fix that issue, the Americans with Disabilities Amendments Act was later passed to clarify that the purpose of the law was not to narrow down or nail down, specific diagnoses, or to narrow the definition of disability, but rather to focus on the outcomes for people with disabilities, and really look at whether or not people with disabilities were receiving equal opportunities, and avoiding those types of discrimination. So with the Amendments Act, the purpose was really to restore the original intent and protections of the Americans with Disabilities Act of 1990. And it did this by broadening the definition of disability, expanding the definition of major life activities to include tasks like reading, concentrating, and communicating. The Amendments Act also stipulated that the determinant of if somebody has a disability should be made even if they can do something to mitigate their disability, right? So things like taking medication or using assistive devices. And then finally, the ADA Amendments Act also clarified that conditions that are episodic or in remission, like epilepsy, for example, or cancer, are still considered disabilities if they would substantially limit a major life activity when they are active. So again, this Amendments Act provided some important clarifications, and helped more people be able to access the protections of the law with less difficulty. Okay, so before we go any further, I think it's important that we just pause to answer the question, what is discrimination, right? So we're talking about the ADA and we're saying, the ADA prohibits discrimination. So really important that we're all on the same page as to what discrimination even is. So discrimination, simply defined as unfair or prejudicial treatment of people based on personal characteristics. So as it pertains to the ADA, discrimination would be the failure to give a person with disabilities the equal opportunity to find, to maintain, and to benefit from employment, the opportunity to participate in or benefit from the services and programs of state or local governments, and the equal opportunity to obtain or use the goods, services, or facilities of places that are open to the general public, which includes most businesses. And we'll talk more about this shortly. And it's important to note that discrimination can be either intentional or unintentional, right? So intention, typically doesn't matter. It's the discrimination and the impact of that discrimination that we have to, that we have to deal with. So, I think many of us believe that most of the time, at least today, in today's world, discrimination usually is unintentional, or is because of a lack of understanding and awareness of what the ADA requires. But that doesn't change the fact that, ADA compliance is the law. So let's look at, how do I know if I'm protected by the ADA, right? So to be protected by the ADA, you have to be considered a person with a disability. That's really the only, sort of eligibility criteria. So this means that a person has to be able to meet the ADA's definition of disability. The ADA defines disability as a physical or mental impairment that substantially limits one or more major life activities. So it's important to remember that in the context of the ADA, disability is a legal term rather than a medical one. And because it's a legal definition, the ADA's definition of disability might be different than what you see being used by Social Security, for example, or perhaps Medicaid, or maybe what the Veterans Administration uses to define disability. So again, the ADA's definition of disability is by design meant to be broad, and it's meant to be construed in favor of easy qualification by a person. So if you have some sort of medical condition that limits your ability to do simple tasks like, talking, seeing, hearing, breathing, walking, climbing stairs, concentrating, thinking, even the functions of your organ systems are considered major life activities. So any of those things, if it's something that most people in the population can do with little or no difficulty, but because of your medical condition, that you experience some difficulty with doing those things, that you meet the definition of disability in that case. So again, there's no exhaustive list of conditions or diagnoses that the ADA uses to qualify, or check if somebody meets the definition of disability. And it's really subjective, right? So one person who has, ADHD may have significant, struggles doing things like concentrating, focusing, executive functioning, time management, those major life activities. While another person with ADHD, maybe they're able to function without much difficulty in those areas. So again, the ADA applies case by case to each individual based on that individual's circumstances. And it's meant to be broad and not, the idea isn't to overly define or narrow down who is and isn't a disability. Important to note, the ADA also provides protections for people with a record of such an impairment or medical condition, right? So if you, if you have a history of uh, uh, a mental psychiatric disorder, but maybe it's controlled with medication, you still have that record of having an impairment. So you still would be protected by the ADA in that case. And then there's also protections under the ADA for people who are regarded as having a disability. So this means that, maybe you're not actually limited in any major life activities, but because some way that you present yourself or the way that you look, other people view you as being disabled. So an example of this might be, if you have one leg that's shorter than the other and you limp, you may not actually have a limitation with walking, but people may view you as limited in some way because of your gait and the way that you walk. So really, in those cases, it's actually the attitude of the other person that is the limiting factor, right? So the way that other people treat you is the thing that causes sort of a disability. So I mentioned that the ADA does not use an exhaustive list of disabilities whatsoever. It's really just that one broad definition of disability. But we can certainly point to and think about some categories of disabilities that we commonly see. These are types of disabilities, that many of the people that we work with and interact with would fall into one or more of these categories. So you have things like physical or mobility disabilities, um, spinal spinal cord injuries, cerebral palsy, limb loss, muscular dystrophy. So again, any of these things that would cause a physical or mobility disability. You have things like blindness and low vision. So again, sensory disabilities that cause vision loss. You have that could be something like total blindness or macular degeneration. You have people who are deaf or hard of hearing. So this is, again, profound deafness or age-related hearing loss could be included here. You have speech and communication disorders. So this would be somebody who might have a stutter or aphasia, or a laryngectomy, for example. Then we have this category of intellectual and developmental disabilities, or IDD. So this might be someone with Down syndrome, someone with autism spectrum disorder, someone with fetal alcohol spectrum disorder. So those would be some examples there. Then we have cognitive and learning disabilities, dyslexia, ADHD, traumatic brain injury, and other related processing issues. Other types of disabilities we could look at are those mental health or psychiatric disabilities. So again, that might be things like major depression, bipolar disorder, post-traumatic stress disorder, schizophrenia. We have neurological disorders, epilepsy, multiple sclerosis, Parkinson's disease, even migraines could be included in this category. Then you have what are just kind of overall chronic medical conditions. Again, so the functions of our organ systems can be considered major life activities. So things like diabetes, Crohn's disease, fibromyalgia, cancer, chemical and environmental sensitivities, severe allergies, could be included in this category, right? Multiple chemical sensitivity. And then you have other multiple or intersecting disabilities. So it's important to note that a person can have multiple disabilities, right? So you can have any combination of the above disabilities, right? So for example, you could have a person who's deaf who also has diabetes. And so that person would have an intersecting or be multiply disabled. So another couple of important notes about disability. Disability can be both apparent or non-apparent. and can change over time or with context. So people can be born with a disability, or they can acquire a disability later in life, right? So we know that, many people are born with their disability and they live with it their entire life, but sometimes we have illnesses, sometimes we have injuries, and most of us are going to acquire a disability as we age. So disability really does impact all of us. And even though many of us will think about, people in wheelchairs or people who have obvious disabilities, most people with disabilities have disabilities that are not apparent. So you can't tell just by looking at them or interacting with them that they have a disability. And sometimes, you might not be able to look at somebody who's deaf and know that they're deaf just by looking at them, for example. But within the context of talking to them, interacting with them, at that point, you may be able to notice that that they have that disability. So again, that visibility, how visible your disability is, can change over time or in different contexts. Okay, so important to note that the ADA also provides some additional protections beyond just, protecting you if you have a disability. But the ADA also protects you if you for exercising your rights. So if you're in the workplace, for example, and you request an accommodation, you say, "Hey, I need something different on the job in order to be able to do my job." And because you made that request, because you exercised your rights to the ADA, your employer starts, disciplining you, giving you poor performance reports, trying to manage you out, writing you up, or even firing you. Um, you that would be you would have additional protections for those types of retaliation or coercive activities. So the ADA provides additional protections for exercising your rights. And then the ADA provides another additional protection for associating with people with disabilities. So if you're a person without a disability, but you have a known relationship with a person with a disability, even if it's not a familial relationship, so if it's a coworker, somebody you volunteer with, somebody you work with, if you have a known relationship or association with a person with a disability, the ADA would provide protection for discrimination in that case as well. And we do see this come up from time to time, particularly with, adults who don't have disabilities, but maybe they have disabled children. Maybe they have uh, maybe they volunteer at an organization with people with certain types of disabilities, and once that becomes known, maybe they're turned down for job opportunities because of that. So the ADA does explicitly prohibit that type of uh, discrimination based on an association with a person with a disability. Okay, so important to think about the prevalence of disability. So we've defined disability. We've thought about, how does the when is a person considered a person with a disability? Am I a person with a disability? And now it's important to think about, you know, am I alone, or how many other people are there with disabilities, right? So you will see different estimates of the prevalence of disability based on who's conducting the study or who's putting out the information. This information comes from the Centers for Disease Control and Prevention, and they estimate that about 28.7% of the adult population has a disability in America. So that would represent about 74 million adults in America who have a disability, in any number of those categories that we mentioned. So and we can, that's further broken down. We can see that 12.2% have serious difficulty walking or climbing stairs. 13.9% have serious cognition difficulties. 6.2% are deaf or have serious difficulty hearing. and 5.5% are blind or have serious difficulty seeing. 3.6% have serious difficulty with dressing or bathing, or what's otherwise known as self-care. And 7.7% of adults in America have difficulty with living independently. So again, you can kind of see how the overall prevalence breaks down into these various categories. And of course, we mentioned that people can have intersecting disabilities. So it's likely that somebody who is blind and also has diabetes might fall into many, more than one of these categories of disability. So I think it's just important to note that, there are many people in America with disabilities. This is, representing more than 1 in 4 people, right? So again, disability rights impact us all, and we should all be concerned with what ADA rights are available to us. Okay, so where do my rights apply? ADA rights apply. So we'll get into what our rights are, but we need to know, where do we have these rights? So first of all, the ADA is divided into 5 main sections, which are called titles. So you could sort of think of these as the different chapters of the ADA. So chapter 1 or title 1 is the employment chapter. So this tells you that the ADA applies, generally speaking, in employment. So we'll talk more about the limitations around the application of the ADA in employment. But generally speaking, if you're employed and your employer has at least 15 employees, they have to provide you with your ADA rights. Title II covers state and local governments. So again, this tells you the next area that the ADA applies. So that's in state and local government entities. So, if it's a town, if it's a city, if it's a county organization, if it's a public school, if it's a public library, if it's a state university, those would all fall into the category of state and local government. If it's a county jail or a state prison, those would also fall under the ADA as well. So any state and local government organizations, the ADA applies. Now, if it's a federal government organization, that's different, and we'll talk about that on the next slide. And then we have Title III, which is called businesses or places of public accommodation. So we'll define that, what is a place of public accommodation here shortly, but this again gives you the third sort of area where the ADA applies. So this could be a for-profit, this could be a nonprofit business, anywhere that the general public can go, where you can access goods and services. Generally speaking, the ADA would apply in that environment as well. And so really, when we think about where do my ADA rights apply, those are the 3 sort of core areas of public life where the ADA applies. So it does have its limitations. But generally speaking, the ADA applies in employment, in access to local government or municipal buildings and services, and access to business buildings and goods and services. So there's 2 other chapters, which we're not going to go into detail on today. Chapter 4 is the telecommunication chapter, and chapter 5 or title 5 is the miscellaneous chapter. So telecommunication provides some regulations for people who have communication disabilities to be able to use a relay service to make phone calls. It also has some requirements for things like closed captioning on emergency broadcasts and public service announcements, making sure that 911 services are accessible to people who have communication disabilities. And then that miscellaneous title, really lives up to its name. So it's got various things like who enforces which parts of the ADA, and we'll talk more about that, how the ADA interacts with other parts of the law, etc. So really just lots of miscellaneous provisions in there. Okay, so what's not covered by the ADA? So this is important information for you to have. So first of all, private membership clubs that truly limit access to members and their guests. Um, so a true private membership club is not covered by the ADA. So they are exempt from compliance with the ADA. Similarly, a religious organization, and the programs and facilities they control would be exempt from the ADA. So that would be things like churches, mosques, synagogues, etc. Tribal governments and programs operated by federally recognized Native American tribes are not covered by the ADA because they do have, they have that sovereignty. So they are able to make their own laws and cannot be compelled to comply with United States federal laws. And then personal residences and apartment buildings that offer no public accommodations or commercial services are not covered by the ADA, but the Fair Housing Act may apply in that situation. Federal agencies, again, may be covered by a different law, and same goes for airplane accessibility. And so we'll talk a little bit more about those other laws towards the end of the presentation. So right now I want to give us a 5-minute break. So let's come back at 11:20 Mountain Time, and we will continue the presentation from there.
Hi, everyone. Thank you so much for your patience. I just got a message from Emily saying that she's having some technical difficulties. Unfortunately, her computer forced her to restart the entire computer is in the process of updating a software. We're very, very sorry for that inconvenience. I don't know what time or how long it's going to take, but I will check back in about 5 minutes. So if you can all please continue with being patient, and I'll have an update for you guys in 5 minutes. So thanks for hanging in there.
Good morning, everyone. This is Maggie. I'm with the Rocky Mountain ADA Center, and as you've seen, we're having some technical difficulties. Always something with technology. If I am able to answer some questions, I would be happy to do so in the interim.
This is Jessica, Maggie. We do have a few questions here. Oh, Jenny, somebody has their hand raised. There we go. I saw the hand raises and they're gone. Okay, we have Deborah Gare. Somebody here has a question. Go ahead and add it to the Q&A part if you wouldn't mind, please. If not, we do have a few questions in our QA. Meantime. So someone's asking if this might be covered, but are HOAs exempt from following 88 laws?
And that's a great question. HOAs don't fall under the ADA, but they usually do fall under what's called the Fair Housing Act or the FHA. And you could call your local FHA entity to get more information on that.
Great, thank you, Maggie. Our next question is, can you talk a little bit more about the protection for individuals who are associated with an individual who has a disability? And if possible, can you give an example of this?
This could be, and it can vary from title or chapters that Emily discussed earlier. But say I have a child who has a disability, and perhaps my employer is concerned that I'm going to miss a lot of days because they perceive my child's disability to be something that may take me away from work. And so while an accommodation, like under Title II, we would not be protected enough to have an accommodation. So as another example, if my child needs to go to the doctor, I'm not necessarily protected to need an accommodation to take the child to the doctor, but I am protected that you would not discriminate against me based on the fact that I have a child or a spouse, someone with a disability. Does that help?
Thanks, Maggie. I have another question also. I am deaf and worked as a chauffeur driver for a few months as an independent contractor. I was suddenly let go without any explanation, and when I asked the person I worked with, she wouldn't tell me the reason. This unexpected termination has negatively affected my income. Would this be considered ADA discrimination?
Well, as Emily mentioned, it depends. Usually, if you are contractually employed, you are not covered under Title I of the ADA. But then it depends. If your contract is with another company that employs, say, chauffeurs, it's possible that if you needed an accommodation, that they would be responsible for an accommodation. So it depends. Generally, I would say no, but you might want to look into that a little more.
Great. Another question is, are there any changes in the ADA with the new administration?
There have not been any that we are aware of. We don't know that anything is even in the works. So far, we have not been affected in any way. So I would say no, not that we are aware of.
All right. Thank you, Maggie.
Mhm.
I am seeing another question here. What is a family of a neurodivergent child with spectrum disorder to do when the PG/CPS's system lacks accountability in child/grandchild receiving FAPE, FAPE? The family has reached out to every entity in PG/CPS's special education program, for example, MDSE and the school board.
If you're, when you say FAPE, um, that goes along with the law of IDEA, the Individuals with Disabilities Education Act, which is a different law from the ADA. So the answers to that can depend on a number of things. One, if hopefully you are familiar with each state's parent center. Every state has a federally funded parent center, and they do work with families to help understand IDEA, FAPE, um, their IEPs, your individual educational program. There's a lot to it. And so hopefully you're familiar with them and have worked with them to get more information. If you're not receiving FAPE, FAPE, and I apologize because my brain, I cannot remember what FAPE stands for, but it's very important under
Yes,
IDEA. Yeah. Um,
it's free and appropriate public education.
Thank you. Perfect.
You're welcome.
Um, that there is a process to go through to file complaints. It is different from the ADA. So if you hopefully you're familiar with that and gone through all of that. Ultimately, for IDEA, I would refer you back to your parent center to get more information about what do we do next. Sometimes these laws do overarch. The ADA could apply if your child is not receiving the modifications and accommodations they need. So you could file a formal complaint if it appears that the ADA Title II is not being initiated. So there's that. You can contact Department of Justice to file a complaint or get in touch with Department of Education. The Rehab Act probably also applies. If this is a public school that receives federal funding, they're going to have responsibility. So you can contact the federal funding source, which is usually going to be the Department of Education. So those are some suggestions. It is difficult not knowing exactly what the situation is, but those would be some starting places if you haven't already.
I'm gonna follow up to that question. Our participant says that they've done that all and they're not doing anything for them, and it's been a 3-year long struggle with them. Is there anything else that you might recommend for them that they can follow up on?
At that point, you probably need to, if you haven't already, contact a legal service, an attorney who deals with educational issues. And there are specific attorneys that do that. And you may have already done that as well. To be honest, it's not always an easy fix, and I'm sure you know that. Those are the suggestions that I have.
Great.
Yeah.
Thank you. Thank you, Maggie. Do you have any what's the thing? Recommendations? Someone said that they'd like to see more ADA apartments or housing in their area. Is there anything that they can
Well,
do?
and apartments and housing do not fall under the Americans with Disabilities Act except for the public access areas. So, for example, the rental office would be a Title III, but the individual apartment and private housing do not fall under ADA. So now you're looking at the law, the Fair Housing Act. Usually you'll have to probably interact with your local community organizations, your centers for independent living. Those are great resources to help you get that help in the community. Those would be my suggestions. I see Emily is back.
Yay.
Yes, I'm so sorry. I can't believe that my computer forced me to restart in the middle of giving a webinar. I really apologize. That's embarrassing. But thankfully, we have Maggie here with us to jump in and answer questions. I really appreciate Maggie and Jess for handling things while I got my technical difficulties sorted. And thank you everyone for your patience and understanding as we got that all figured out. So now we can just jump right back into it. I hope there's been some good questions and discussions happening. So jumping right back into it, we had just finished talking about what's not covered by the ADA. So again, we talked about those private clubs, religious entities, tribal governments, and personal residences. Personal residences being covered by the Fair Housing Act, federal agencies being covered by the Rehab Act, and the Air Carrier Access Act applying to airplane accessibility. So one of the questions that I got from somebody's registration had to do with grandfathering. Are there any buildings or organizations that are grandfathered into not having to comply with the ADA? So I want to clear that up and just let you know that there's no such thing as grandfathering. So, if you fall into one of those categories, employer, state and local government, or business, you will have some sort of compliance responsibility. Okay, so let's get into the good stuff. What are my rights under the ADA in employment, right? So we're going to dig into this a little bit further. So I mentioned that Title I of the ADA, this is the employment chapter or portion of the ADA. This applies to all private employers with 15 or more employees and all state and local government employers, regardless of the number of employees that they have. And just like with all parts of the ADA, this prohibits discrimination against qualified individuals with disabilities in employment practices, right? And this applies to all of the aspects of employment, everything from recruiting through hiring, application, interview, promotion, training, pay, and any other sort of benefits or things that employees enjoy during the course of their employment at an organization. So the Title I of the ADA, or this employment portion, is enforced by the Equal Employment Opportunity Commission, or the EEOC. And so we'll talk a little bit more about enforcement towards the end, but it's important to note that Title I, so employment, always goes through the EEOC. So that's different than what we see with the other titles. So employment rights. So you have the right as a person with a disability to be considered for hiring, promotion, and training based on your qualifications for the job, not anything to do with your disability. So you should be able to, be considered for any job for which you are qualified, regardless of whether or not you have a disability, as long as you can perform the essential functions of that job with or without a reasonable accommodation. And so with that, you have the right to request and obtain a reasonable accommodation to perform those essential functions of the job. You have the right to engage in an interactive process with your employer to identify those effective accommodations. You have the right to keep your disability-related medical information private and shared only on a need-to-know basis. So this means that if you never need an accommodation on the job, if you're perfectly, you have no problems getting your work tasks done, your disability does not interfere with that, you never have to disclose that you have a disability at any point. You have the right to keep that private. And if you choose to disclose that you have a disability because you need an accommodation, you have the right to expect that your employer is going to keep your disability related information private. And that's going to be kept separately from your main employment employee file, and that information is not going to be shared with anybody who does not need to know. So the only people who should need to know anything about the fact that you have a disability or need an accommodation are people who are responsible for implementing that accommodation. Okay, so you have the right to receive equal pay, benefits, and privileges, the same pay, benefits, and privileges as your coworkers without disabilities. And you have the right to be free from harassment, retaliation, or coercion when you're exercising your ADA rights. So we talked about those, that additional protections around exercising your rights. So with the ADA, when it comes to employment, the most common thing that comes up for people with disabilities is this idea of needing a reasonable accommodation on the job. So the ADA requires that employers provide reasonable accommodations to the known physical or mental disabilities that a qualified applicant or employee with a disability has. So again, you do have to be qualified for the job, right? So if you need to have a certain education or credential in order to qualify for the job, that employers can require that. But as long as you're otherwise qualified for the job, you should be able to request a reasonable accommodation if you need one to be able to perform the essential functions of your job. And a reasonable accommodation is really simply just any modification or adjustment that might be made to an employment practice, to the work environment, or any other practice or process on the job that would make it possible for you to perform those essential job functions or enjoy an equal employment opportunity. So when it comes to making this request and going through the reasonable accommodation request process, both employee and employer have responsibilities here. So this is really, really by design meant to be kind of a two-way street. This is called the interactive process. So generally speaking, it is your responsibility as a person with a disability to request an accommodation or to disclose that you have a disability and that you need some sort of accommodation on the job. So, in almost all cases, this is something that you have to, this is a process that you have to initiate as the person with the disability. And then the employer needs to work with you in order to do a few things, right? So the employer may need to verify the need for the accommodation. Sometimes they may request medical documentation or documentation from a therapist or a rehabilitation counselor, just anybody who's qualified to speak to, your disability related limitations. So the employer may need to verify the need by requesting accommodation. So you will be responsible for providing, requesting documentation, and you will be required to provide that documentation if needed. So generally, an employer shouldn't ask you for documentation if the need for the accommodation is obvious, right? So if you're clearly in a wheelchair, it generally wouldn't be necessary for the employer to request documentation that you're in a wheelchair and you need an accommodation related to that. But if it's one of those non-apparent disabilities that we talked about, sometimes the employer can't tell just by looking, or it's not obvious. So they may need to request that sort of documentation. And then both parties, the employee and the employer, need to participate in that interactive process, right? And both parties should participate in good faith. So the interactive process means that this is a back and forth, ongoing conversation about what reasonable accommodation can be implemented. Testing it, making sure it's effective, talking about it periodically to make sure, does anything need to change? Is it possible that there's a more effective option? So really continuing to engage in that ongoing dialogue. And I will say this is one of the areas where employers tend to violate people's rights, as they don't continue to have that ongoing conversation with people about the accommodations they ask for on the job. So that's something to look out for. You have the right for your employer to maintain that conversation with you about your accommodation request. And when we say that we're participating in this process in good faith, we mean that the employer should believe that there's an accommodation that will work. They should be working towards a solution, believing that this is going to, result in a win-win for everyone. The person, you as a person with a disability will be able to stay engaged in employment. And that's kind of participating in good faith is the opposite of, just going through the process so that they can check a box, and just doing it because they have to. Participating in good faith means that there's an assumption that this is going to result in a positive outcome. So when we use the term reasonable accommodations, there's really that emphasis on the reasonable aspect of it. So any request that you make should be considered reasonable. And again, this is always case by case. So what's reasonable to one employer might not be reasonable for another employer. But some examples of things that could be considered reasonable accommodations would be things like making modifications to the physical environment so that the facility itself is more accessible, restructuring your job so that marginal tasks or non-essential job functions might be eliminated or redistributed. flexible scheduling. So this could just be, allowing you a 15-minute window to arrive to the work site, or, just again, any sort of flexibility that might work to help mitigate some aspect of your disability. It could be acquiring new equipment. It could be providing qualified readers or sign language interpreters. It could be modification of application and testing procedures and training materials. So if your employer requires that you take an annual, cybersecurity training, but the training that they offer doesn't have captions and you need that for accessibility, that's an example of a reasonable modification or a reasonable accommodation the employer could make. Okay, there are some things that are kind of widely understood to be not reasonable, reasonable requests for accommodations. So eliminating job functions. Employers are not expected to eliminate essential job functions in order to accommodate you as a person with a disability. They're also not required to lower production standards, that they genuinely require and that they genuinely apply to all employees. Employers are also not required to provide you with any sort of personal use items. So they don't have to provide you with, glasses or wheelchairs or any sort of personal use, assistive devices, anything like that. Employers also do not have to excuse violation of conduct rules. So this is one of the things that we always recommend to people with disabilities is, don't wait until you start getting in trouble to request an accommodation. You want to request your accommodation as soon as you know that you're having an issue doing your job, because the employer does not have to excuse violation of policies that happened before you requested that accommodation. Employers do not have to change your supervisor or give you a new supervisor as a reasonable accommodation. And then there are these other categories of unreasonable requests called undue hardship and direct threat. So if you request something that's an undue hardship, that means that it's something that's going to be significantly difficult or expensive for your employer to provide. And usually an undue hardship is something that's both difficult or expensive to provide. If you request something that's a direct threat, pretty straightforward, that's going to be something that causes a significant risk of harm or a threat to the health and safety of either you or other people. And so that would be considered an unreasonable request. But it's important to note that undue hardship and direct threat are really considered narrow exceptions. They shouldn't be something that your employer easily defaults to, right? They should be really narrow exceptions, and your employer should provide you, if they're making a decision about undue hardship or direct threat, they should provide you that rationale in writing. So they should give you something in writing that explains why it's an undue hardship or why it's a direct threat. And even if something that you've requested, is claimed to be undue hardship or direct threat, the employer still needs to work with you in that ongoing interactive process to try to find another effective solution that does not constitute an undue hardship or direct threat. So again, that interactive process and that ongoing working together is really, really critical under the ADA. Okay, so what about rights under in public places, right? So, so this is where we get into that Title II of the ADA, which is local governments, and Title III, which is businesses. And so these two titles, while there are some differences, in a lot of ways, there are a lot of similarities. So for today's presentation, I'm just going to kind of combine those. So Title II applies to, again, state and local governments. So we talked about cities, towns, counties, anything like that is a state or local government. Like all parts of the ADA, it prohibits discrimination against people with disabilities in accessing programs, activities, and services that are offered by that government agency. Title II is also where we see those public transportation regulations. So going way back to the beginning when we were talking about ADAPT, this is where we see, all of that activism come to fruition with those public transit regulations. And Title II is enforced by the United States Department of Justice. So this is now a different enforcing agency than what we saw in employment. Okay, so Title III, very similar. So this is for what we call places of public accommodation, which are just broadly defined as most businesses or buildings that offer certain goods or services to the general public, both for profit and nonprofit, as I mentioned. So that could be things like hotels, restaurants, bars, theaters, grocery stores, banks, and the list goes on and on. So again, you've got that prohibition on discrimination, so non-discrimination requirement here. And people with disabilities need to be able to enjoy the goods and services that are offered by that place of public accommodation. And again, this is also enforced by the United States Department of Justice. So, this will be no surprise to you all. In places of public accommodation, both a government and business, right? Some of the most common barriers to equal access we see are things like physical obstacles, like stairs without ramps. We see communication barriers, like a lack of sign language interpreters or Braille. Attitudinal barriers that people have, that stem from misconceptions or assumptions about people with disabilities. And then what I call rigid requirements or a lack of flexibility. So when people have policies in place that screen out or tend to screen out or cause barriers for people with disabilities, and they're not willing to make any changes or modifications to those policies. That's what I think of as a rigid requirement and a lack of flexibility. So in public places, you have the right to enter and use most businesses, nonprofits, and government facilities without encountering significant physical or service or programmatic barriers. You have the right to receive goods and services with the same ease, quality, and timeliness as people without disabilities. You have the right to expect removal of architectural or physical obstacles, or that you'll be given some alternative method of accessing the goods or services available at that public accommodation, whenever that's readily achievable. You have the right to request reasonable changes to policies or practices that might block your participation. So reasonable modifications in policies or practices. You have the right to obtain information in accessible formats, or really just have be communicated with in a method that's effective for you. So if you need captions, if during a meeting, if you need ASL interpretation, if you need information in Braille, you have the right to obtain those auxiliary aids and services. You have the right to access state and local government programs, activities, and public transportation in the most integrated setting possible. So you should not be segregated or, made to be apart from, being integrated with the general public. And you have the right to be free of surcharges or added costs, being levied upon you because you have those disability related needs. And one of these organizations may need to pay for something to provide you with access. So they cannot add surcharges or pass those costs onto you. So again, very much like Title I, really the big thing that we see, couple of main concepts we see within the ADA under Title II and Title III. First is this idea of reasonable modification. So you'll notice this is very similar to when I was talking about reasonable accommodation in employment. But for Title II and Title III or public accommodation, the terminology is reasonable modification. So this is a change in a policy, practice, or procedure that could be done to offer equal access and equal opportunity. So some examples of this can be very formally making modifications, or it can just be doing informal on the spot modifications. So examples of reasonable modifications might be things like permitting a service animal to go where the public may go in a building, even though animals are normally not allowed. Accepting proof of proof of identification outside of a driver's license, because some people with disabilities might not have a driver's license. So that policy or practice might need to be modified if that's something that's being required. Sometimes an organization might need to modify something like a no outside food or drink policy if a person, needs specific food or, needs to have food on hand because of a blood sugar issue or allergy. So again, sometimes you might have a formal policy in place that needs to actually be modified. But sometimes, or businesses and governments can make these modifications on the spot without much, without much formal process having to take place. Okay, next we have effective communication. So again, we talked about the fact that sometimes if you have a disability that impacts your ability to communicate, whether that's because you're blind or you're deaf, or you have a speech disability, organizations are required to provide you with some assistance to facilitate that effective communication. So the idea here is that information must be as clear and understandable to people with disabilities as it is to people without disabilities. And what gets provided to the person with the disability, that's going to vary person to person, right? Because not everybody needs or requires the same thing. Okay, so I know we're coming up on the end of our allotted time here, so I am going to continue just because we had a bit of a delay and I want to get through this information. But please be aware that if you have to jump off and move on to something else, the rest of today's presentation will be available in a recording, which we will post on the website sometime next week. And I'll make sure that everybody who joined today gets an email letting you know where that's posted. So again, my apologies for the technical difficulties. I do want to just continue and wrap up here in the next couple of minutes. So if you can stay, great. But if you need to go, we understand that too. Okay, so what should I do if I think I might need an accommodation or a modification? So what does this request process actually look like? Right? So the first thing you need to do is you need to make a request. And these processes, while they're pretty similar, they do differ a little bit in employment versus in public places. So I've kind of broken it down into these two categories. So in employment, usually this request is going to go to either your direct supervisor or to your HR department. So again, this will depend somewhat on what the type of employer you have, how big the employer is. But usually we're looking at talking to our supervisor or to our HR department. You can make a request for accommodation at any time during employment, even if you did not disclose that you had a disability when you were hired. So you may know that you have a disability when you get hired. You may think it's going to be just fine. And then you get on the job and you discover, you know what? I do need a reasonable accommodation. And that's okay. The employer cannot penalize you for not disclosing that you had a disability right when you were hired, or making that request, earlier on in the duration of your employment. So when you make this request, it's really helpful if you can identify the task, barrier, or policy that's limiting your performance or your access in the employment environment. So if you can explain to the employer what work task you're having trouble with, that's really helpful. You don't have to provide the employer with your diagnosis, with the medications you take, how long you've had your disability, what's going to happen to you. You don't have to provide any of those sort of invasive details. You simply need to tell the employer, I've got a medical condition or disability, and I'm having trouble with blank work task. Right. And if possible, it's also helpful if you have some ideas for a solution or a reasonable accommodation that can be implemented. So you may not know if this is a brand new disability, you might not have a solution. You might just say to your employer, I just got this diagnosis and I'm having trouble with this work task. I'm not sure what the best accommodation would be, but, I'm hoping we can work together to figure it out. But if you do happen to know, for those of us who've lived with disabilities for a long time, oftentimes we know exactly what would be helpful. So if possible, identify which solution you'd like to request from the employer. Again, as I mentioned before, you may be asked to put this request in writing. Sometimes employers have certain policies where they want you to put your request in writing, or they want you to document your accommodation request using a specific form that they have, through the HR department. So in public places, again, similar process with a few key differences. So usually if it's a government entity, usually you're going to look for an ADA coordinator, particularly in larger municipal organizations. There should be a specific individual who's been designated the ADA coordinator, who you can make the request for modification of a policy or auxiliary aid or service. If this is just a business, a restaurant, a hotel, a bank, you may need to speak to either a frontline staff person or perhaps somebody in management. So sometimes there are instructions for this type of thing on the business's website. Other times you may need to just speak to someone and make the request. They may direct you to the most appropriate person after you have that initial conversation. So again, really helpful if you can make note of the specific barrier that you're having issue with, and kind of what issue it's causing you. That way the staff can take that request and have enough information to know how to tackle it accordingly. So what issue are you having with, and what would be a good modification or solution to this issue, right? Okay, so now you've made a request. So then what happens after I make a request, right? So when I make this request, then what's going to happen? So again, employment, and in public places, this could play out a little bit differently. So in employment, the employer should acknowledge your request in a timely manner, and they may also ask some follow-up questions to clarify the request. So that would be normal and expected. So they should pretty quickly get right back to you, acknowledge we've received your request, and then if there wasn't enough detail in order to process the request in your initial request, they may ask some clarifying questions there. And then at that point, you're in that interactive process. So remember, this should be a two-way dialogue between you and the employer, where you talk about and explore different effective accommodation options. So what might work? Can we do a trial basis? I'm not sure if this will work, or I'm sure that this is the best option for me. Again, you're going to work together to figure out those accommodation options. Again, we talked about the fact that the employer might request some limited medical documentation if that disability is not obvious. And you may work together with the employer to test or compare multiple different solutions, especially again, if this accommodation is new to you. After you've made your request, your employer should issue you a formal decision about the request. And again, you should expect something in writing. So, typically you're going to get a something that says your accommodation request has been approved. your accommodation request has been approved, but with a modification. So maybe we're not going to provide you with this exact chair that you asked for, but we found one that will be equally effective. And so we've made this accommodation with a modification. Or the employer, for whatever reason, may choose to deny your accommodation request. And again, you should expect some information in writing that details a clear explanation, especially if you've been denied. And if you've been approved, you should expect some information about a timeline related to when the accommodation is going to be implemented and who would be sort of like your point of contact for that. And then, then if your accommodation is approved, it's going to be implemented. You should periodically review the effectiveness of your accommodation, either with your supervisor or HR department, whoever your point of contact is. Disabilities can change, workplaces can change. So sometimes accommodations need to change as well. If your request is denied and you feel that was done in error, then you can certainly appeal internally, or you can file a charge of discrimination with the EEOC, and we're going to talk more about that shortly. So, similar but different process in public places. So again, staff or the ADA coordinator is going to take your request and record and gather those details. They're going to evaluate the request for feasibility. They may provide some temporary fix in the meantime. You should receive a prompt response from them indicating, whether they're going to make that change, whether they have an alternate solution to suggest or implement, or whether they'll just deny your request. And again, you should ask for that in writing with some reasoning behind that. Hopefully modifications can be quickly approved and carried out. And if staff need to be trained in order to facilitate that modification, that process happens quickly. And if the response is inadequate, or you're denied, and again, you think that is in error, you can escalate your requests to somebody higher up in the organization, upper level management, town, if it's a local government, maybe the town administrator, whatever the case may be. And then, of course, finally, your recourse, it would be to file a complaint with the Department of Justice or other civil rights agency. Okay, so we're getting close to the end here. What should I do if I think my ADA rights have been violated? So again, this is pretty straightforward in both situations. You want to keep a good record of what happened. You really want to document what happened, what request you made, what steps you took to facilitate getting that accommodation or modification. You want to notify either the employer or the business, that, hey, I feel my rights have been violated. I'm requesting an immediate correction or fix of this issue. If the organization has an internal grievance procedure, it's helpful to follow that procedure. This is especially the case with a local government agency. You typically would find a grievance procedure. So again, you can go up the chain of command in the organization. And if you still have trouble resolving the issue, or you just want to follow a complaint, or you have some other different goal, what we recommend is that at that point you contact your regional ADA center, or some sort of other disability advocacy, or information organization to give you technical assistance, guidance, and support, and help walk you through those next steps. If you are going to file a charge of discrimination with the EEOC, that should be done within 180 days of the date of discrimination. And you can also file a complaint with the United States Department of Justice for public places. I don't believe there's the same level of time limit on that, but it is always best to file your complaint as soon as possible, as soon as you know that that's what you want to do. And you may also, you know, if the enforcing agencies aren't able to resolve your issue or take your case, you can always choose to retain a lawyer and file a lawsuit in federal court. So, you know, really most importantly, you want to contact somebody, a resource for information. So if you feel your rights have been violated, contact, you know, the ADA National Network, your local ADA center, the Job Accommodation Network, you know, one of these information resources, and we can help walk you through those next steps and figure out exactly what would be the right process for addressing that violation. You can also contact some resources for advocacy, like the independent living centers, protection and advocacy centers. The ARC is a great advocacy organization, the American Association for People with Disabilities, and the National Disability Rights Network. And then, of course, you know, we have these resources for enforcement here. So you have state civil rights offices that you can file complaints with, the United States Department of Justice, as we mentioned, the U.S. Equal Employment Opportunity Commission. And then there's some other resources on the slide for filing complaints for airlines under the Air Carrier Access Act, and housing under HUD, the Department of Housing and Urban Development. All right, so again, I think I mentioned this already, but just be aware that there are other federal disability rights laws that go beyond, you know, and apply to different areas than the ADA. So we mentioned fair housing, we mentioned air carrier access, we mentioned the Rehab Act and the Individuals with Disabilities Education Act. There's also the Help America Vote Act and many others. And there's a link on this slide here where you can find a comprehensive guide to these other disability rights laws. So with that, I will wrap it up. And again, I apologize for the technical difficulties and the lateness that we've gone over our time now. I think for the sake of time, you know, perhaps we can go ahead and wrap up our session today. If you didn't get your question answered during Maggie's Q&A session in the middle, please do feel free to send in your questions either to us or to your local ADA center, and we will be more than happy to address your questions at that point. So thank you very much, everyone, for being here today. And again, please do email us if you would like a certificate. And with that, we will end today's session. So thank you very much.